All right, we'll call this afternoon's docket. William Andrew Wilson III, CR 18-521-522, CR 19-327. So understanding that Mr. Wilson's entering a plea today?
Not today, but we do have an agreement. We came to an agreement and we need to set it for a plea so we get the paperwork together and get them signed up.
Oh, let me look at my case. I'm wondering why I set it for a plea today.
We've been working towards a resolution, and I believe Tyler and I came to the agreement yesterday. I was able to relay the final bit of it this morning to my client judge.
Yeah, I just wrote that down incorrectly on my docket because I looked back on my last docket and it's for docket call today. Anyway, so you were saying that you and Mr. Woodwife worked it out?
Yes, Judge, we've reached
We
an
did,
agreement.
we just need we don't need much time, just 30 days or less.
And what's is there going to be a holdup or is it just about getting the papers done?
It's about getting the papers done, and my client informed me that there was some back time from when he was originally arrested in Smith County. Long story short, I don't think Van Zandt County wanted to come get him from Smith County, and so I want to make sure that that's reflected in the judgment and paperwork. But there's no real holdup, Judge.
Okay. Can we come back next week on the 6th? Are you available on the 6th or the 8th? I don't want to reset it for 30 days if it's just about doing paper. I'd rather get him signed up and getting processed and let him go where he needs to go.
Sure. Next week is really, really challenging. It looks like, do you have any, are y'all having court on Friday the 9th? I just have,
No,
I'm just covered up on the 7th and 8th.
no, I've got the 6th and the 8th. Are you covered up all afternoon on both of those?
I am, Judge. I've got meetings with the parole board, Anderson County on Tuesday afternoon. Then I'm covered up in the 392nd on Thursday. I'll be with you in the morning though. What about the week of the 19th?
Hey, tell me that again. You'll be with me in the morning on what day?
The 8th.
Hang on just a second. Let me check with my coordinator here. Maybe we can work it out to where we can have him zoomed in from the jail that morning. Hang on just a second.
Oh, okay, great.
All right, Mr. Ryan, what about, what if we set it for, say, 11 o'clock on July 8th? And then I'll just, my staff will assist in getting Mr. Wilson there in the jail court, and we Zoom him over.
That's great. That'll be great, Judge.
All right, let's do that. We'll set him then for plea next week on the 8th at 11.
Okay, he signed the reset, Judge.
Okay, All right, Mr. Wilson, we'll see you next week then.
Thanks, sir.
You're welcome, sir.
Thank you. That's all I have. Maybe excuse.
Yes, thank you, Mr. Weiner. Yeah.
Ms. Thompson. Oh,
All right, Ms. Thompson, are we ready on Mr. Davidson? Or I'm sorry, Mr. Cox?
yes, sir. Mr. Cox, yes, sir.
All right, this is cause number CR 21-55, State of Texas versus Harley Davidson Cox. Mr. Cox, if you will raise your right hand, sir, I'm going to place you under oath. Mr. Cox, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, put your hand down. Do me a favor and just speak up as loud as you can, okay? I know it may be a little bit awkward because you're there and I'm here, but I have a court reporter here and it's going to be very difficult for her unless you speak up, okay?
Yes, Your Honor.
All right, thank you, sir. All right, Mr. Cox, your name is Harley Davidson, right?
Yes.
Okay, and are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you?
Yes, Your Honor.
Do you feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, Your Honor.
And throughout this paperwork where your signature appears, are you telling me that it is your true and correct signature and you've only signed the documents once you were satisfied what they said?
Yes.
All right. Ms. Thompson, do you believe Mr. Cox to be competent today?
Mr. Cox is competent, Your Honor.
And you've explained to him his legal rights with regards to this case?
I have.
All right. Mr. Cox, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. That carries a range of punishment of not less than 5 years or more than 99 years or life, confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Any sentence received in this case must fit within that range of punishment. I see here that the plea agreement you want to enter into with the state would be to 8 years in TDCJ with a $2,500 fine, with you paying restitution, court costs, reimbursement fees, having an unfiled case or a filed case considered and closed. In addition, you would receive 213 days credit time for the time that you have spent in jail. Is that the plea agreement as you understand it?
Yes, Your Honor.
Okay. Then understanding the plea agreement and the range of punishment, Mr. Cox, how do you plead?
Guilty.
Mr. Cox, are you pleading guilty to this charge because you are guilty of committing it?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, the court will accept Mr. Cox's plea of guilt. Ms. Thompson, is there any objection to states 1, the stipulation of evidence?
None, Your Honor.
All right, states 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, state is abandoning the enhancement paragraph, but we have nothing further beyond that.
All right, thank you, Mr. Woodwide. Anything further from the defense, Ms. Thompson?
None, Your Honor.
All right, I'm just going to review the evidence.
Hey, let's go ahead and get Cody on the way. Thank you.
All right, the court's reviewed the evidence. I find there is sufficient evidence to support the plea. Court will follow the plea agreement in this case. The court convicts Mr. Cox of the first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams but less than 200 grams. Court will follow the plea agreement and assess punishment at 8 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a fine of $2,500. Court orders restitution of $180, court costs of $290, and reimbursement fees of $20. Court takes into consideration under section 1245 DA 2020-1177, a tamper or fabricate with physical evidence. Court also awards Mr. Cox 213 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Cox, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the deputy to be fingerprinted. Once you are released from TDC, Mr. Cox, it's important that you report to the courthouse so that you can make arrangements to discharge the fines and court costs, restitution, and fees so that a warrant doesn't issue for your arrest as soon as you're discharged. Okay?
Yes, sir.
All right. Good luck to you, sir.
Thank you.
Your Honor, that's all I have, baby. Excuse, sir.
Yes, thank you, Ms. Thompson.
All right. Oh,
I don't think so. Sleep there. Deputy McLeish.
Yes, Your Honor.
I'm looking through my docket here and I see that Mr. Ashmore has a client, Philip Myers. And Mr. Ashmore filed a motion for continuance. He's at a funeral today and the court reset all of the mourning cases for Mr. Ashmore. And so I'm going to do the same for Mr. Myers. And I'm going to reset his pretrial hearing to July 6th. So if you want to, if he's not there, then there's no need to bring him up. If you'll just send a message to him that Mr. Ashmore's at a funeral, that he asked for the case to be continued. I'm not sure that I had granted the continuance in e-file, but it was my intent to do so. So no sense to bring him up and cause jail staff to deal with that.
Okay, Your Honor, I don't see him on my docket. Could I get his first name, please?
Yes, Philip Patrick Myers. And if you have the court's docket, it's changed. The attorney name is now by first name alphabetically rather than last name for whatever reason. So it's on my page,
Okay.
my page 11 between William Wilson and William Ivy. But if he's not on your docket,
Okay,
don't concern yourself.
okay, very good. And Your Honor, we do have Mr. Covey up here as well. Is Mr. Knoll ready?
Let me see here. No, I think it'll be 141. Well, it says 145 and it's past 145. No, Mr. Knoll said
Yes,
he's
sir.
logging in, but he's not logged in yet.
Okay, then we're in a holding pattern out here for the moment, sir.
Yes, ma'am. Just let me know.
Thank you. Good afternoon, Mr. Knoll. You're muted. You're trying to talk to me.
Good afternoon again.
Thought maybe you were doing that on purpose. That was a secret signal you were trying to send me.
No, not yet.
Okay. I'll wait.
I think this is my fourth trip, so to speak, into your county this week.
Kurt, who you got today?
Cyber threat?
Apparently, Covey is in jail that was supposed to be there this morning. Now, I don't know if he's in jail because of a new charge or bond violation or not paying the bondsman or what. No idea.
And he is near the room.
Has he committed a new offense?
Do y'all know?
As far as I know, I couldn't pass the UA and they pulled them off.
He couldn't what?
He says that he says he believes they pulled his bond because of a UA.
Well, now that actually doesn't surprise me at all. I'm gonna finish eating my TV dinner, so I'm gonna see ya.
Mr. Knoll, are you ready on Mr. Covey?
Yes, I believe, it's my understanding that the reason Mr. Covey is back in jail is because of a inability to pass a UA. So I don't know if that happened today or when, so I don't.
No, that happened the last time all of us were in court together. It just
Okay.
on the jail docket. Here's our announcement form.
Okay,
And then let me show you this other one. And so on that same day, let's see here. Find No, it's not one to display, but
well, I guess basically that's what I was getting at. I didn't know if that was a drug issue that might still be something in his system, or we're clear of that.
well, we were in court on May 11th and he admitted to using methamphetamine on 5/8 of 21. And so he was on surety bonds of 10,000 and 25,000 respectively for possession and injury. Court found him to be in violation of his pretrial release, and I put him back in custody on that date. It just didn't make the jail docket. It stayed on the bail docket. So anyway, his bonds are at 20,000 and 50,000. He's been in custody since.
Okay.
So we're set for docket call today.
Well, I guess maybe I should speak first here is the court might be able to guess. He has yet to come in to view any discovery on either case. He has sent to me a long recitation as to what his opinion is, so to speak, of what happened on the injury to a disabled person. My recollection as to what the offer was, don't know if it still is, but what the offer was back at the last docket call involved a very long probation with Safe P or 6 years TDC. So that's kind of where I am, I guess.
And does that mean Mr. Covey's rejected those and is asking the court to put him on the jury trial docket?
Judge, I'm not saying he's rejected either of those, since he's never actually come in to review any of the discovery in either case. I'm not sure how you can reject offers on cases where you don't know what the discovery is.
Well, I showed today is the third setting for docket call. We arraigned him on January 5th. We had pretrial on February 23rd, docket call on April 1st, docket call on May 11th, and then docket call today. So, Mr. Covey, I need to know, are you accepting the state's plea offer, or do you want me to set you for trial?
The plea offer is what? The TDC offer?
State, can you outline the offers again, please?
Yes, Your Honor. The state was offering 10 years probated for 10 years with Safe P as a condition, or I have in my computer that Mr. Knoll talked me down to 4 TDC in the alternative if Mr. Covey is not interested in probation and Safe P.
I'm interested in probation. Yes, sir. Yes, sir. I also have been having some suicidal tendencies here the past week and a half, and have attempted to hang myself. So I talked to a person at the Andrew Center, the suicide hotline, and I'm also she's wanting me to seek help through the state hospital, the state mental hospital. I'm sorry, Your Honor.
All right, Mr. Knoll, if are you coming back in July? I'm wondering if I shouldn't reset Mr. Covey for a week or two, give you a chance to come visit with him in the jail, share with him what the discovery is and let him make an informed decision on whether or not he wants to accept one of the state's offers.
Judge, that'd probably be a good idea. I'm gonna move my laptop just a second so I can
Sure.
see my desktop calendar, which is easier. I'm more of a paper than a digital guy, I guess.
No, I understand.
Uh,
I just didn't know if I already had you scheduled.
Judge, how far into July? Today's, well, next week I'm a little bit everywhere. The week after, I don't know if the court has anything, say the 15th or the 22nd or anything like that.
Are you here at all next week? On the 6th or the 8th?
I don't believe so, Judge. It looks like I'm Smith County or Wood County. In fact, Wood County, I think, is the 9th.
And so what about the 15th? You said you're here on the 15th?
I'm not there on the 15th, but I can be there on the 15th.
What about the 13th?
13th, actually, it looks like I may have an arraignment in your court anyway, so I think 13th would work.
All right, what I'm gonna do, Mr. Covey, is I'm gonna set you for July 13th, so that's not even 2 weeks, okay? And Mr. Knoll's gonna
Yes, sir.
bill, and he's gonna talk with you about your cases. Make sure you understand what the evidence is that the state intends to use against you. And then you need to let Mr. Knoll know what you want to do, because when we come back on the 13th, you're either going to tell me that you want to accept one of those offers and we're going to resolve your case and do it that day, or I'm going to set you for jury selection and then you'll just stay in jail until your case is reached for trial. Okay? And
Yes, sir.
go ahead, Mr. Knoll.
Judge, just for clarification, the 10 probated for 10 with safe P, that would be on both cases, I believe, because I can't recall if the drug case is, I think the drug case is also a 2 to 10.
I'm not sure. It looks like it's a state jail to me. So I'm not sure if the state's offer is, and state, just go ahead and clarify. If it's 10 pro 10 on the third degree, obviously the max on a state jail, I believe, is 5. So that must be the offer on the injury case.
Judge, I don't believe that the state jail is enhanced. I believe that our intention was for him to take a deal in the third degree and then 1245, the dope charge into that.
And then, Ms. Heisel, you indicated that somehow I managed to get you to 4 TDC.
That's what I wrote down.
All right. Okay. Well, we'll talk about both those issues. Judge, I'll try to get up there to visit with him, obviously before the 13th, so we can have papers one way or the other.
Okay. And then obviously I need you to take into consideration his statement that he just made to the court about suicidal tendencies and mental health, and assess that for me and maybe contact the jail staff. So Mr. Covey, if the jail's arranging for you to meet with Andrew Center or anybody like that, I want you to continue to follow whatever recommendations they have for you. Okay.
Yes, sir, Your Honor.
All right. So we'll see you back on July 13th, and that'll be in the afternoon.
Yes, sir.
And Your Honor, may I have that cause number again, please?
Yes, it's CR 20327 and CR 2154. So again, CR 20327 and CR 2154.
Thank you, sir.
Judge, by any chance, was Mr. Couch also in Van Zandt County who didn't show this morning?
I do have information. Let me get it from my coordinator real quick.
Thank you, guys.
brother come in?
Yes, sir.
What are you doing here, man? Oh, nobody told that. We can rain, so you're saying.
Mr. Knoll,
Yes, Your Honor.
the information that I have on Mr. Couch through Ms. Taberham is that Mr. Couch indicated that he was trying to get a ride to be in court this morning. They was waiting on it. The ride never came. He started walking, and that he's near the courthouse now, but he's walking out to the jail because that's where we told him to be at 1:30. He says he can be
It's in
there,
the lobby.
and that
Have
was
a seat in
5.
the lobby. Dude, in the lobby.
Okay.
I'll be right with you.
That's me, before I know.
That may be him now.
He said be there in 10
Mr. Knoll,
minutes.
Your Honor,
I'm sorry.
there was a fellow that stepped in while I was on the phone. I think he may be who y'all are looking for right now.
Yes, Mr. Joseph Couch.
Are you Joseph Challenge?
Timing would be impeccable if it was.
Hello, Jeff.
Mr. Couch?
Yes, sir.
Okay. All right, this is cause number CR 2153, State versus Joseph Brian Couch. Mr. Couch is set for arraignment today. Mr. Knoll, have you met Mr. Couch at all?
I have not, Your Honor. So I have not had the opportunity for him to even see the indictment in the case. I don't,
All right, give me a second.
Judge, I have the indictment. I don't know if it's clear enough just to hold it up to the camera or not.
That's old school, Mr. Knoll. That's old school. Like you. So I'm going to come to your rescue here.
Okay, thank you.
All right, so let me do this. Mr. Couch, can you see this document?
Yes, sir.
All right, I'm gonna scroll down through here and let you read this. Tell me when you're done reading.
Okay. Okay. Okay, sir.
Okay. I'm just gonna go ahead and leave this up. Mr. Couch, here in this document, is your name spelled correctly?
Yes, sir.
Do you understand that you have been charged by indictment? This is an indictment with the second-degree felony offense of tampering or fabricating with physical evidence. And you see here that what that means is that they're accusing you of attempting to alter or destroy or conceal narcotics with intent to impair its verity or availability as evidence in the investigation, and that you did that while a traffic stop or investigation was pending or in progress. Those are the elements of the offense. You understand that's what they're accusing you of?
Yes, sir.
The range of punishment for this offense, if the enhancement paragraph, which is highlighted here, if this is proven to be true, and they're alleging here that you have a prior conviction out of Smith County on this date and this offense, if they prove that, that would increase your punishment range to that of a second-degree felony, which carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice. You understand that range of punishment?
Yes, sir.
Mr. Couch, do you want the prosecutor to read this to you, or are you fine with waiving the reading of this on the record today?
You can go ahead and waive that, sir.
Okay. All right. So at this time, I'm going to find that Mr. Couch has presented with a viewing copy of the indictment in this case, that his name is spelled correctly, and that he waives the formal reading of the indictment. Mr. Knoll, do you want to enter a plea on behalf of your client?
All right, this time for the purposes of arraignment, we would enter a plea of not guilty to the charge.
All right. The court will enter a plea of not guilty into the record for Mr. Couch, and we'll set this for pretrial hearing. And I want you to look at your calendar again, Mr. Knoll.
Judge, if I can get Mr. Couch in, I'd like to go ahead and set him on the 13th also.
You want to set him that soon?
I've reviewed the discovery.
Okay. Mr. Couch, if I set you here in 2 weeks for another hearing, do you believe that you can get to Tyler, to Mr. Knoll's office, so you can sit down with your attorney and let him show you the evidence? Do you?
Yes, sir.
And I don't want you to tell me that just because you think that's what I want to hear. I need realistically, I mean, you had to walk to the jail today.
Yes, sir.
So you're,
I'll make sure that I have.
okay.
Sorry, you're cutting out there.
Okay, no, it's okay. I just stopped talking when you did. All right, so I will set you
Okay.
for a pretrial hearing on July, was that 13th, Mr. Knoll?
It was, Your Honor.
I'm gonna set you for 2 weeks, again in this court at 9 a.m. And you need to get to you need to stay in contact with Mr. Knoll. You need to go to his office, review that evidence with him, okay?
Okay.
Judge, and I want to make sure that he has my information, that he has my phone number and address if necessary. Not Canton weekend, not this weekend, but I might be able to come there as long as he can get to Canton. So I don't have a problem because I've got to go see Mr. Covey anyway. So.
All right, well, let me do this. Let me put you and Mr. Couch in a private breakout room real quick. That way, you can share all that information. Deputy McLeish can help you write that down. That way it's not on YouTube.
Thank you, Judge.
You're welcome. So if you'll just accept this invitation.
Judge, I've given him my contact information, and I believe that's all I have, unless I've got another straggler.
I don't see anymore. I don't see anymore. So I appreciate you hopping back on for us.
No problem.
Thanks, sir. We'll see you soon.
Thank you, Judge.
All right, you're welcome.
Bye-bye.
Mr. Schmidt, have you gone over the indictments with Mr. Larsey?
I have, Judge, I filed a waiver on Mr. Larsey. It should be in your inbox. We've got it set for August 10th date, or for pretrial.
Okay, I haven't seen that, but you're telling me you filed it.
I e-filed it this morning early.
Let me go see if I've got it. Is he still in custody?
He is, Judge.
But he's not in the courtroom right now, is he?
He is, Judge.
Oh, he is?
Yes, he's here.
Yeah, I don't have any waivers, so let's just go ahead and bring him up and we'll arraign him and set it and be done with it. You want me to pull those indictments up for you, Mr. Schmidt, or you comfortable
Well,
with?
sir, we've gone over his indictments. We understand what he's charged with in both causes. He understands the range of punishment and his name spelled correctly. In addition to that, we're pleading not guilty on both. We wait for formal reading. And like I told the court, the waiver that I filed this morning, we had asked that pretrial be set for the August 10th date.
All right, this is cause number CR 2178, CR 2179, State versus Daniel Scott. Laracy court finds that Mr. Laracy waives the formal requirements of arraignment. Court will enter his plea of not guilty into the record for each cause and set each cause for pretrial on August 10th. And that will be at 1:30, Mr. Laracy, if you're still in jail. If you make bail in this case, then it will be at 9 a.m. So if you make bail in the case, then your next court setting will be in the morning, not in the afternoon. You understand?
Yes, Your Honor.
Okay. Who else are you ready on, Mr. Schmidt?
Judge, Mr. Ives here. He's prepared to enter a plea.
We also going over paperwork. Are you ready?
Judge, we've signed all the paperwork. I've given that to Deputy McLeish.
Okay. Can you go ahead and tell me which case or cases we will be pleading on and lay out all the terms for me?
Judge, on each of the cases, that's CR 19313 through 316, we're entering a plea on each. There's a separate packet on each. The plea agreement is the same on each. It consists of the plea of guilty, 10 years TCJ, 0 fine, to run CC on all four. We are, the state has agreed to abandon the deadly weapon allegation and finding. And other than that, it's essentially the same.
What are the court costs?
The court costs on, well, I'll go row by row. CR 19313, court costs are $290, reimbursement fee of $90. 314, $290 and $90. 315, $290 and $70 reimbursement. And then 316, $290 and $70.
And what about Mr. Ivy's credit time in each case?
Judge, he's got 1 day credit time.
Is that towards all?
Yes, sir.
All right, Mr. Ivy, if you'll step up. All right, Mr. Ivy, if you'll raise your right hand, I'm going to place you under oath. Mr. Ivy, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. You're going to have to make sure you speak up louder so my court reporter who's here with me in the courtroom can take down everything you say, okay?
Okay.
All right. You are William Dwayne Ivy, is that correct?
Yes, sir.
Mr. Ivy, are you a United States citizen who reads and writes and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Anxiety disorder and bipolar.
Anxiety disorder and bipolar?
Yes, sir.
Are you currently on medication for either or both?
Yes, sir.
Do you feel like that medication is assisting you today and giving you the ability to have rational thought and understanding of the proceedings here today?
Yes, sir.
In this case, good. I'm glad to hear that. In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss all of your cases with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And where you have signed, are you telling me that that is your true and correct signature and you only signed once you understood and were satisfied that you understood everything that you were signing?
Yes, sir.
Mr. Schmidt, do you believe Mr. Ivy to be competent today?
I do.
And you've explained to him his legal rights with regards to all of his cases?
Yes, sir. I have.
All right, Mr. Ivy, you are charged in each cause number with the same charge, which is an aggravated assault with a deadly weapon, which is a second-degree felony offense and carries a range of punishment of not less than 2 years or more than 20 years confinement in TDC and a fine not to exceed $10,000. That means any plea agreement that the court were to approve today would have to fit somewhere within that range of 2 to 20 and a fine not to exceed $10,000. Do you understand that full range of punishment? And you've heard Mr. Schmidt read to the court or recite to the court rather what the plea agreement is in this case. Is that your understanding of the plea agreement also?
Yes, Your Honor.
And that's what you're asking the court to approve today?
Yes, Your Honor.
All right, then Mr. Ivy, I'm going to ask you at this time, how do you plead to aggravated assault with a deadly weapon in each cause? CR 19, 313, 314, 315, 316.
Judge, I'm sorry, sir, but cause number 314 is a manslaughter charge. Cause number 313 likewise is manslaughter. The other two are aggravated assault with a deadly weapon. They all have the same range of punishment, obviously, and the plea agreement is the same, but just so the courts are aware that it's a different charge.
So you're saying 313 and 314 are manslaughter charges?
That's
Correct.
correct, Judge. I'm not sure why the docket reflects them all as the same charge.
All right, give me just a second. Let me make sure that the clerk's file is correct. All right, court has reviewed the clerk's file and I do find that the indictments returned in each of these causes reflect what I've been told and that it's been entered incorrectly as to the clerk's record. I don't know why that is either, other than maybe the CJIS was the CJIS changed by the state, or they filed in as aggravated assault with deadly weapon and the state changed the charge to manslaughter perhaps. Was trying to figure out why we don't have accurate records here.
That might be possible, Judge, if the victims expired after the initial arrest.
Okay, so let me go back, Mr. Ivy, CR 19-313, CR 19-314, you're charged with the second degree felony offense of manslaughter, which carries a range of punishment of not less than 2 years or more than 20 years, and a fine not to exceed $10,000, and likewise in CR 19-314. While I was reviewing the indictment, I did see that the state alleged a prior conviction as an enhancement. Is the state abandoning that as part of the plea today? Because it was elevated to a first degree.
Yes, Your Honor.
Okay, so the state's abandoning, the state's asking the court not to have an affirmative finding of a deadly weapon as alleged?
Judge, I would defer to Mr. Schmidt on what the paperwork reflects in terms of the enhancement paragraph. However, it is our agreement to abandon the deadly weapon finding, because I do believe that the 10 would still fall within the first degree. So just whatever the paperwork says, Mrs. Curry made this deal with Mr. Schmidt. We'll honor whatever the paperwork has.
And Judge, the judgments accurately reflect the discussions that I had with Ms. Curry. There is no affirmative finding of a deadly weapon on any of those judgments as we agreed to. In addition to that, there are no pleas of true on any enhancement paragraphs on the judgments either. So they're all reflected in the judgment as a second degree 2 to 20.
Okay. All right, Mr. Ivy, then let me ask you, how do you plead to the offense of manslaughter in CR 19-313, CR 19-314, and how do you plead to aggravated assault with a deadly weapon in CR 19-315 and CR 19-316?
Guilty.
Mr. Ivy, are you pleading guilty to each one of those charges because you are guilty of committing each one of those charges? All right, the court will accept Mr. Ivy's plea of guilt in each cause. Mr. Schmidt, any objection to states 1 in each cause?
No objection, Judge.
All right, states 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. State, if you can go ahead and give me a recitation of the facts to support the plea.
Judge, if I could back you up just a little bit and put a couple things on the record. First of all, the CJIS was originally an ag assault that we changed the charge after the victims expired. So you're dead on about that. And then also there is a victim impact statement in this cause. We would ask you to review that before sentence is pronounced.
All right, and the victim impact was provided to the court, and the court, in anticipation of the plea, has reviewed the victim impact statement.
Thank you, Judge. This, Your Honor, arose out of a traffic accident. Mr. Ivy was driving, and we don't know exactly. We believe he might have fallen asleep, drifted into the oncoming traffic lane, hit a vehicle head on. That vehicle crashed out, and then Mr. Ivy struck a second vehicle head on. There were 2 adults and 2 children in that vehicle. One of the adults and one of the children ultimately succumbed to their injuries, and that's where the manslaughter charges arise out of. The other adult and child in the vehicle were seriously injured, taken to the hospital, but have recovered from those injuries. The troopers on scene saw in plain view a marijuana pipe and some marijuana in the vehicle. Mr. Ivy also indicated that he had taken some sort of prescription earlier. Off the top of my head, I don't remember. I believe it was Xanax, but Mr. Schmidt can correct me if I'm wrong about that. They attempted to get a blood specimen from Mr. Ivy. However, his physical condition, they were unable to obtain a specimen. So we don't know exactly the the levels in his system, but we do believe that that drug usage led to the situation we were in, where unfortunately we did have deaths in this motor vehicle accident.
Mr. Schmidt, any objection to that summary?
Judge, no objection to the summary. I would say that based on the statements and the evidence, Mr. Ivy had been driving for approximately 14 hours. And so based on my understandings and my discussions with him, ultimately he did fall asleep, which caused the accident. The other issues pertaining to either marijuana or Xanax, those issues I addressed with Ms. Curry. It's uncertain whether or not they contributed to the actual event, but ultimately Mr. Ivy did tell the trooper on scene and admit to those things. So for all intents and purposes, we received it as though it was a contributing factor.
Thank you.
And
And
that's,
Ms. Heisel is the DA's office. Obviously, I read the victim impact statement, so you appear to be in compliance with victim notification. Are the victims who survived this, are they supportive of this plea agreement?
Judge, I can't personally speak to that. I know that Miss Cheney has been in contact with them. Like I said, this was Miss Curry's case that she negotiated, so I have no personal knowledge of any particular conversations, but I do know that those conversations have been occurring.
Okay, and so you're not aware of any counter position by the remaining surviving victims?
Not aware if there is any, Judge.
Okay. All right, then based on the evidence, the court will follow the recommendation of the state. I'm going to find that there's enough evidence to convict William Dwayne Ivy of the offense of manslaughter in CR 19-313 and CR 19-314 and aggravated assault with a deadly weapon and CR 19-315 and CR 19-316. Court will convict Mr. Ivy of each of those offenses. The court will assess the same sentence in each offense pursuant to the plea agreement and the recommendation of the Van Zandt County Criminal District Attorney's Office at 10 years confinement in the Texas Department of Criminal Justice. The court will not make an affirmative finding as to the deadly weapon. Court finds that the state has abandoned the enhancement paragraph as alleged in each indictment. Court will assess court costs at $290, reimbursement fees at $90 in CR 19-313 and 314. Court will order court costs of $290 and reimbursement of $70 in CR 19-315 and CR 19-316. Court will award Mr. Ivy 1 day credit towards his sentence for the time that he has spent in jail on each of these causes, and the court will order that these sentences run concurrently. Mr. Ivy, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you go with the bailiff to be fingerprinted.
Mr. Ivy, you come this way, please.
that's all I have, Judge. Can I be excused?
Yes, sir. Thank you, Mr. Schmidt.
Thank you.
Mr. Ivy, you're right there.
All right, that concludes this afternoon's docket.
Thank you, Judge.
Thank you very much. We'll adjourn and we'll see you all after the 4th of July. Hope everyone has a safe and enjoyable 4th of July weekend. Mr. Woodwike, make sure you wear sunscreen.
Judge, I produce natural sunscreen. It's called Sunburn.
Me as well.